Hello, I am Friends tonight. I'm a partner in Gowling WLG's Toronto office. I'm a member of the Business Law and Mining Group, and I'm also the leader of the Latin American practice.
And I'm Brett Kigetsu. I'm a partner in Gowling WLG's Vancouver office, and I'm a trustee of the firm. I've been practicing in the area of mining and M&A law for over 26 years. Welcome to part 2 of our 3-part Mining in Focus mini-series focusing on Latin America.
If you're developing or acquiring a project in Latin America, there is a lot you need to know.
What to look out for? Geopolitical considerations, greater control over resources with new laws and taxes, antitrust approval, bilateral investment treaties, and with all of this, the importance of retaining qualified and experienced local counsel. Latin American countries have rich endowments of important metals and minerals. Collectively, they host approximately 48% of the world's copper reserves, 50% of the world's silver reserves, more than 60% of the world's lithium reserves, 20% of the world's gold reserves, and an undetermined percentage of the world's potash reserves.
It's no surprise then that mining companies with projects in Latin America closed or announced in 2021 at least $900 million plus M&A deals, with a combined value of $9.2 billion. Almost half of the deals in 2021 targeted lithium assets, ahead of a forecast boom in demand for battery metals, driven largely by electric vehicles and the decarbonization of economies worldwide.
When considering the acquisition of a mining project in Latin America, one important factor is the rising level of geopolitical uncertainty in the local jurisdiction where the target has operations, as many countries are considering populist changes in policies, which will have long-term harmful effects for the affected industries, in particular mining. In addition, in an environment of high commodity prices, some governments in Latin America, and other countries around the world for that matter, are looking to capture a greater share of profits by, among other things, increasing taxes and royalty rates. In fact, according to the latest report from risk consultancy Verisk Maplecroft, there is a clear 4-year trend in mineral-rich nations seeking greater control over the revenues generated for their natural resources. And this is a trend that's expected to continue over the next 2 years. The same study concludes that Latin America is the region where the risk of expropriation and/or tax hikes has increased the most.
Given these factors, in addition to conducting a very thorough due diligence, we strongly recommend that you consider using an acquisition entity incorporated in a jurisdiction that has a bilateral investment treaty, also known as BIT, with the host country. A bilateral investment treaty is an agreement between two countries regarding the promotion and protection of investments made by investors from their respective countries in each other's territory. This will enable you, as a foreign acquirer, to potentially have recourse against the host country if it expropriates your mining project.
Now, also consider corporate and tax structuring to address tax and foreign exchange control issues, as well as bilateral investment treaties as mentioned before. We would recommend retaining a Big Four accounting firm to structure your acquisition, having regard to the funding of the acquisition and funding of operations in the host country, and to later repatriate income out of the host country, all in a tax-efficient manner. Many times, restructuring post-acquisition can be very costly, and in some cases even impossible due to regulatory constraints.
Note that each Latin American jurisdiction may have filing and antitrust approval requirements. If you or the entity to be acquired originate revenues in the host country from the sale of products, the provision of services, or subsidies received by any entity in the acquisition group, all the way up to the parent company, if certain monetary thresholds are met, the government in that jurisdiction may have antitrust approval requirements. The analysis generally also includes revenues produced by the target operation in the host country. In many countries, if antitrust approval is not obtained, the transaction may not proceed, or if the transaction closes prior to receiving approval, it may need to be unwound, or the approval may come with conditions which will require the acquirer to divest certain assets or operations. For that reason, before deciding to proceed, consider reviewing these factors, as unwinding in whole or in part a transaction can prove to be very costly.
We're seeing a trend in Latin American countries to increasingly scrutinize acquisitions of mining properties in their host countries that contain critical minerals or battery minerals. Most foreign acquirers purchase shares of offshore holding entities that indirectly hold mining properties in Latin America. If you are acquiring the shares of a foreign entity that indirectly controls a mining property or an operation through a local entity incorporated in the Latin American host country, be aware that such indirect acquisition could constitute a change of control of the local entity and trigger filing and approval requirements. We also note that a significant number of mining projects in Latin America are indirectly held by Canadian incorporated companies. If you are a non-Canadian entity and you wish to acquire the shares of a Canadian incorporated company that indirectly holds a mining asset in Latin America, note that the acquisition will require filing and potentially receipt of approval under the Investment Canada Act and also potentially the Canadian Competition Act.
Given these factors, we strongly recommend that you retain qualified local counsel in the foreign jurisdiction to provide transaction advice and to conduct comprehensive due diligence on the assets. Note that in particular, in addition to experience in mining matters in the host country, significant experience in international transactions and regulation and working with international lawyers is key.
Finally, if you are a Canadian publicly traded mining company, or you are seeking to become listed on a Canadian stock exchange, you may be required to prepare and file a technical report in respect of the target's property in accordance with the requirements of Canadian National Instrument 43-101 when the property to be acquired is material to you. There are accommodations available under the regulation that can provide you with additional time to prepare the technical report. However, even with these accommodations, we find it's often a challenge to have the technical report prepared in a timely manner. As such, we just suggest that you discuss this with your counsel at the outset.